Good afternoon, everyone, and welcome back to the Florida Elder Justice Conference and to this session on elder law ethics representing clients with diminished capacity. Our speaker for this session is Juan Carlos Arias, managing attorney with the law offices of Anidjar and Levine. Juan Carlos focuses his practice in the area of Florida lawyer regulation, lawyer ethics consulting, state professional licensing, law student representation before the Florida Board of Bar Examiners, and unlicensed practice of law. He became bar counsel for the Florida Bar in 2005 and is one of 6 attorneys responsible for the investigation and prosecution of attorneys who violated the rules of professional conduct in the counties of Broward and Palm Beach. And thank you very much for joining us today. All right.
Thank you, Kathy. Thank you, Christy, for the invitation. It's a pleasure to talk to everyone across the state. Very important topic, representing clients with diminished capacity. And let's get started. Let's get to it. I believe that the agreement is that you can submit questions, and I believe Kathy or Christy are going to read them at the end of the presentation. So I'll respond to them in that way. That way we maintain a flow and less interruptions. Flows better in Zoom this way. So submit your questions as we move forward here. As Kathy said, this is what I do, ethics. I do ethics at the Supreme Court level of the Florida Supreme Court, and also I do Florida Board of Bar Examiner cases. I also represent individuals who have licenses in the state of Florida. Normally their systems of discipline are very similar under statutory law. So that's what I do for a living, and today's topic is super important for many reasons. Let's put in perspective what we're talking about. According to the Alzheimer's Association 2021 report, it just came out, millions of Americans are living with Alzheimer's or other dementias. More than 6 million Americans are living with Alzheimer's. By 2050, this number is projected to rise to nearly 13 million. Is going to more than double in the next 30 years. As the size of the US population, age 65 and older, continues to increase, the numbers of Americans with Alzheimer's or other dementias will absolutely grow, and both the number and proportion will escalate rapidly in coming years because the population of 65 and older is projected to grow from 58 million this year to 88 million by 2050. And based on estimates, 11% of people aged 65 and older in the US have dementia. 1 in 3 seniors dies with Alzheimer's or another dementia. And here we have a little pie to show where we are as of 2020. As you can see, Alzheimer's disease is the most common cause of dementia, accounting for an estimated 60% to 80% of cases. So why are these numbers so important? Well, the likelihood of an attorney encountering clients with diminished capacity is very high. The probabilities are probably in the 90s or 100s. We will see as this population grows old that you will see more and more numbers, especially from all of those who we call the boom, the boom generation. So that is a reality, and lawyers with elder clients, and many of you obviously practice elder law at some level are presented with unique challenges. Challenges sometimes take the form of capacity issues, how to handle clients' lack of lucidity. What are the requisites for mental capacity to transact? What are the steps to take as attorneys to protect themselves? How to identify a sufficient degree of client lucidity? What's the attorney's burden of diligence? Those are the questions that come up as an ethics attorney. And we're going to discuss some of the best practices out there to protect yourself and better serve our clients with declining capacity. Some of the steps that we're going to discuss come from many different sources. So I've gathered a lot of ideas for you to consider. And also, we're going to look at some rules of assessment and conduct that are going to help you guide you through this process when you raise that flag of maybe my client has some diminished capacity issue. Of course, we can't really talk about diminished capacity and your ethical duties without first looking at some of the signs of diminished mental capacity. Many of us, if not most of us, in this presentation have witnessed or had to live through that, most likely through an elder parent or grandparents. As in my case, my grandparents did have some issues of Alzheimer's later in life. So we all know some of these signs, confusion and all of that. But let's go over it. We may have some younger attorneys that are looking at serving our elderly population, and they may not be familiar with that. So the first thing I want all the attorneys that have clients or are jumping into elder law at some level through state or any other of the areas that really get a lot of elder clients in, is establishing familiarity. The interactions from the initial meeting as to legal tasks over time may change. So it is very important that from the beginning you establish with these elderly clients a relationship where that interaction can be measured as you progress in the legal work that you're going to be providing. Of course, estate planning is probably one of the biggest areas. So you got to take your time to become familiar. This is not a client that just comes in, you do the business, out. These things are normally prolonged type of representations, and the better you familiarize yourself with that client in the front end, and the best service you'll be able to provide and comply with all the ethics regulations as you progress. Be aware that a client may have lucid mental capacity in the initial interactions, but may begin to struggle over time during the representation. And I'm sure many of you have lived through that, where you have somebody that you start working with at some point, and then you start noticing a decay in the mental capacity 2, 3, 4 years from that initial consultation. And be sensitive to changes in persons accompanying the client, and be alert to signs of undue influence. And all of you who have had elder clients who come with family members know exactly what we're talking about. You got to be very, very in tune with the things that are happening in front of you. Don't be naive. Be connected. Okay. All of the above mentioned observations are unique to each client. So not all clients are the same. Not all client interactions with family members are the same. So all of this is fluid. There's no equation where you put A, B, and C, and yeah, we have an issue of capacity. So you gotta, that's why the establishing familiarity is so important where you're going to engage in a, most of the time, a long-term relationship with these individuals because of the issues they're dealing with, obviously. So be aware, establish familiarity, categorize the issues, and document your file. It is very important that you create a paper trail of these observations. That way, when you see that client 5 months from now, or 7 months from now, or a year from now, you can always go back to your notes that should be detailed. These practicing and helping elder clients requires more time than the usual client. Understand that. Dependence of client on others for details about finances, property, debts. These are things you need to notice. These are things you need to note. Recollection of past events, confusion about recent events. We all know that that is something that happens, in people with declining mental health. As you know, uh, and I experienced that through my grandma. My grandma would remember things from 1920, 1925, but she couldn't remember what she had for lunch an hour earlier. These are signs that you need to understand. It is a common uh, sign of something, being being out of relationship. Disorientation is also a sign that you want to document and keep that file, on it. Attendance by other persons to legal consultations. It is very important. And all of you who represent elder clients that are driven around by family members, usually there's a family member that takes the responsibility of driving and taking care of the family member. Most of the time, there is that daughter or brother that or son or daughter that are the ones that I don't want to say get stuck, but are the ones upon which the family relies on providing the services, taking mother to get her hair done. You know what I'm talking about. So when there's a change of a family member, those are things that you need to notice and perhaps be a little bit inquisitive about, so you understand what's going on and who is coming into the new life, because you may have become accustomed to talking to the daughter, but now suddenly there's another family member showing up, or a paid person driving this individual. These are all things you need to keep your eye open to, because these are changes that should be documented. Again, don't be naive. These are not normal clients. These are clients that require establishing familiarity with as this process of that you're helping them with concludes. Assistance with travel. Be engaged. When you serve our elder population, if that is the business model you're going to follow, providing services to this population, you need to be engaged. Don't make the mistake of treating an elder client as a regular client. Be engaged in the representation. Build a relationship. You owe it to them and to yourself. Goal of the representation, whatever that legal matter that you're assisting with, and whatever it is, an attorney should strive to identify the client's requisite capacity to understand the legal task. You must feel comfortable that that client is there because the client wants to be there, that that client understands what the task at hand is, and which direction that client wants to go freely. Okay, so this is a very important ID you got to do from day one. So you need to assess the client's ability to understand the task and the client's ability to appreciate the consequences of the actions taken. And of course, the always ever present red flag in the mind of the attorney is awareness of mental illness symptoms to spot a mental illness when representation commences. It's very important that you take the time. This is not a 20-minute meeting with an elder client. It requires some time for you to start establishing that bond and understanding who you have in front of you. Dementias, other disorders, be aware, take the time. There is no shortcut to assessing the capacity of an elder client. Per the American Bar Association, there is a presumption of capacity. Still, it is best practice for all of you helping, representing elderly clients to, at the initial meeting, pay close attention to the client's articulated goals and reasoning. Give the client a chance to explain. Pay close attention to the client's state of mind. Review your notes on point 1 and 2 here before subsequent meetings to verify the consistency or any deviations. You all know that have worked with elderly clients that some days are better than others, and they may have an impairment that is very noticeable one day, and then lucidity the following week or 3 weeks later. It's normal. It's a pattern of the aging process when it comes to capacity. So your notes, you should always take the time to have a mental picture of who the person is. Look at those notes. Yeah, when we met the first time, these were the issues. This is where what I noticed. And then you're meeting again for the 5th time. Take the time. Again, these are cases that require familiarity and constant assessment, as some of these dementias and diminishing capacity is progressive. So you're already alerted because of the age that you have to do this. So you have to take the time. So this is not the case where somebody shows up to your lobby and you simply, hey, how you doing? Come in, let's get business. No, you have to take the time. Okay, do your homework and keep taking notes. Take notes. Take notes. Observations. Take notes. Let's talk about the ABA model rule of professional conduct. Client with diminished capacity is rule 1.14. A says, when a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority or mental impairment or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. So the area in yellow is the bottom line of this model rule. Maintain a normal client-lawyer relationship. B, when the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest in your assessment, the lawyer may take reasonably necessary protective action, take steps, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, you even want to seek the appointment of a guardian ad litem, conservator, or a guardian. So point B, The lawyer may take reasonable, necessary protective action. That's in yellow. That's the highlight of that one. And C, information relating to the representation of a client with diminished capacity is protected by Rule 1.6 when taking protective action pursuant to paragraph B above, the one that we just read. The lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client. So C tells you you are allowed to disclose whatever is necessary to seek that assistance. A, B, and C, very important concepts to protect really that client. The comment to the rule is really where the meat is, as in most of the rules that we're familiar with. And it actually covers these areas: client-lawyer relationship, the taking of protective action, disclosure of client's conditions, and emergency legal assistance. Those are the four big components of the comment. And I obviously invite everyone to look at those because it gives you more, it expands on the rule that we just read, 1.14. Now let's talk about the Florida Bar rule on diminished capacity. If you notice, the rule starts with a 4, but it retains a 1.14, which is the model rule that we just read from the ABA. So the rule in the Florida Bar is 4-1.14, client under a disability. That's the title of that rule. And you're going to see similarities, obviously, because our rule is based on the model rule from the ABA. Letter A says maintenance, maintaining a normal relationship. Remember that wording from the prior slides. When a client's ability to make adequate, considered decisions in connection with the representation is impaired, whether because of minority, mental disability, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. We heard of that concept before. B, appointment of guardian. A lawyer may seek the appointment of a guardian or take other protective action with respect to a client only when the lawyer reasonably believes that the client cannot adequately act in the client's own interest. Very similar to the prior rule that we read. And the comments. Comments really expand on this essential terminology of A and B, which is A, B, treat those clients with diminished capacity as any other client as much as possible. And 2, if they need somebody to safeguard their interests, you could consider some sort of protectorate, from the different options that we have through the legal process. So what does the bar tells us, the Florida Bar, about this client-attorney relationship? The comment tells you that the normal client-lawyer relationship is based on the assumption that the client, when properly advised and assisted, is capable of making decisions about important matters. When the client has diminished capacity, which is really the area that we want to concentrate on, maintaining that ordinary client-attorney relationship that may not be always possible. In particular, an incapacitated person may have no power to make legally binding decisions. Nevertheless, a client lacking legal competence often has the ability to understand, deliberate upon, and reach conclusions about matters affecting the client's own well-being. Furthermore, to an increasing extent, the law recognizes intermediate degrees of competence. For example, children as young as 5 or 6 years of age and certainly those of 10 or 12 are regarded as having opinions that are entitled to weigh in legal proceedings concerning their custody. So even at that level of capacity of very young individuals, they do have says and they do have opinions. So that's that the rule is making the point that, hey, let's let's truly measure not the legal capacity, but let's measure the ability to understand the task and the consequences. Because that's at the end of the day what this is all about. You, as the attorney, advise and take action based usually on those two things. And the comment here is actually saying that in a different way. So also, it is recognized that some persons of advanced age can be quite capable of handling routine financial matters while needing special legal protection concerning major transactions. Again, making a difference that hey, is not the end of all things. The fact that someone may not have the legal capacity, but they may still be able to comprehend, what the representation is all about. The comment also tells us that the fact that a client suffers a disability does not diminish the lawyer's obligations to treat the client with attention and respect. If the person has no guardian or legal representative, this is very important, the lawyer often must act as the de facto guardian. That's in the comment of the rule. So you can't just say, oh, he's just a client. Depending on this mental diminishing capacity, you must act. If there's nobody else, you must act as a de facto guardian. That is a comment to the rule. Even if the person does not have a legal representative, the lawyer should, as far as possible, accord the represented person the status of a client, particularly in maintaining communication. So you're going to be very careful. If a legal representative has already been appointed for the client, the lawyer should ordinarily look to the representative for decisions on behalf of the client. If a legal representative has not been appointed, the lawyer should see to such an appointment where it would serve the client's best interest. This is a decision that you have to have in the back of your mind as you assess these clients. And when you just start seeing some diminishing capacity, these are the things you got to be thinking about. Okay, these are the things you're going to be weighing, what you're looking at, and what your ethical duties are. And it may come at a point where you believe that having a third party seek the best interest of the client so you can continue the legal representation purely, it may be a consideration at some point. An evaluation of these considerations is a matter of professional judgment on the lawyer's part. There's no equation, again, there's no book for you to make this decision. You got to be alert. And that's why familiarizing yourself with these clients early on is so important. Because if you haven't spent the time, you haven't taken the notes, and you're going to the second, third year of representation, it's going to be very hard for you when you start seeing some slipping on the capacity. You have to do the homework. Again, there is no shortcut for you to maintain a professional judgment on these elderly clients. There's no shortcut. You got to do the homework. You got to take the time. If the lawyer represents the guardian as distinct from the ward and is aware that the guardian is acting adversely to the ward's interest, look at this. The lawyer may have an obligation to prevent or rectify the guardian's misconduct. Think about it. They're putting a responsibility on you, even though there's a third party that has been assigned through the law. You still remain a bastion of defense. You still have to speak on behalf of that client. Think about it. This is a comment to the rule. You have an ongoing obligation. Even if you are the one representing that third party. That's what that says. So again, be alert and understand that you're on the hook, okay? That's why your observations and your familiarity with the client and the case is so important. The comment also tells you a little bit more about disclosure of client's condition. As the ABA rule stated, there are parameters for you to follow if you have to disclose in order to assist that client with diminishing capacity. And the rules of procedure in litigation provides that minor persons suffering or individuals suffering mental disability shall be represented by a guardian or next friend, or if they do not have a general guardian. However, disclosure of the client's disability can adversely affect the client's interest. The lawyer may seek guidance from the appropriate diagnostician. That means that the rule is telling you be active, be proactive, educate yourself, okay? Again, you are ingrained in this representation in a way that is a little bit different from a regular client out there, okay? And you need to realize that and be sensitive to this rule. It's a different rule, okay? It's a different rule. It gives you a lot of responsibilities that are not usually there, when you're representing other individuals. So be sensitive to that. Understand. There's an ethics opinion from 85 that was reconsidered and approved on September 10, 98. And a quick quote on it: an attorney whose client becomes mentally ill during the pendency of her dissolution of marriage. That was the question that was at stake there in that opinion. Has a duty to safeguard the client's interests and may seek appointment of a guardian if the attorney believes the client cannot adequately act in her own interest. So that's just an opinion on point. It deals obviously with family law, but it obviously can be seen in the context of other areas. And of course, malpractice considerations are always there because, as you know, at the end of the day, there is a component to that based on your acts and omissions. So, reasonable belief is the lawyer's standard for determining when a client's condition moves from difficult to the level of diminished capacity. So, you got to be engaged. Your senses have to be in that representation. And I found this quote from Lawyers Mutual of Kentucky, of all places. In investigating whether a client has diminished capacity, a lawyer may obtain relevant information from sources such as family and friends, concerned parties, healthcare providers, social services, and professionals. The one thing to be sure not to do is to jump to conclusion or fail to thoroughly investigate. And you investigate by observing, asking questions, taking notes. The whole point of this quote is, again, reinforcing the importance of the engagement of the attorney, treating these individuals with diminished capacity with more attention to detail than usual. It encourages you to ask questions, to also have a relationship with the individuals around that client. It is time consuming. It is time consuming, but there's no shortcut to the representation because you're seeing the duties of care that the bar rules are placing on you by the ABA and, of course, adopted in a similar fashion by the Florida bar. So the rules themselves tells you this is special. This is special. These are special clients. These are not the clients that you're going to rush. These are not the clients that you're going to see for a few minutes. No, because in order for you to provide the attention to detail that the rules require when you represent elderly individuals with potential diminishing capacity, they are asking you to take the time to be concerned, to ask questions, to look at the sources of info, to clarify for you where we are on the mental, situation. That's what these things are saying to us. The ABA Commission on Law and Aging. According to the ABA Commission on Law and Aging, a lawyer must be able to answer two questions in the affirmative as they analyze, as they decide if that client has the capacity. Does the client have the capacity to contract with you? So you ask all the questions. You seek an affirmative opinion in your mind as to all the issues, the tasks, etc. How the client explains what they want done. You put all of that in your brain. And then, does the client have the capacity to complete the legal transaction? So, the consequences. Take it to the final step in the legal representation. These are things that have to be in your mind, and you need to feel comfortable about it and document it. Not let it stay in your brain. You need to put it in writing because you got to create that record, okay, that you did your homework. As the ABA reminds us, regardless of a particular client's mental state, we are in a position to help people who trust us and seek out our advice. That's the bottom line. Our job is to identify that task and take it to fruition. Period. That's our job. And regardless of the mental state, there's lots we can do to represent these individuals. Okay. And that's what that bottom line from the ABA reminds us. That is very important. Don't give up. Find a way to be able to assist that client in a professional and ethical way. I invite you to look at some of the resources out there. There's a handbook for lawyers, and there's a second edition already from the ABA that has been prepared by the Commission on Law and Aging and the American Psychological Association. And it's an assessment of older adults with diminished capacity. These are tools for you to use to make sure that you educate yourself and apply the recommended concepts, okay, in order to protect yourself, but more importantly, properly represent individuals who show a diminished capacity. I relied on several articles that are here. I also got some of our initial information on aging and dementia from the 2021 Alzheimer's Disease Facts and Figures from the Alzheimer's Association. And good time now to address some questions, if any. Kathy and Christy.
Okay, we've got one question here that if a client is found incompetent by the examining committee for the guardianship, doesn't the divorce get put on hold for 3 years?
I don't know that particular procedural answer to the person that is asking. I don't practice in family law, so that statutory requirement or procedural requirement is not my area of expertise, and I would apologize. Yeah, I cannot answer that question.
Okay. What about this question? When you have an older client who comes in with another person, typically a child, and they want to take care of some legal matters, often to transfer property or to get a will, what procedure do you use to make sure that the person, the older client, is doing what they want to do?
Yeah, I've seen it done in many different ways. I think that the way that I prefer, if it's possible, and of course, you need to at least have that initial meeting with the family member in order to, assess the relationship, see what kind of influence you can perceive between these two individuals. But I like to always meet with my clients at some point, one-on-one. So I think that a very, if possible, because you got to read this individual. Some family members may feel uncomfortable with that, but I would, and I have in the past said, "Hey, I need to address several issues, with your dad or whatever. I'll need about 10, 15 minutes in private, and I'll ask the questions that I feel will fill me in on how lucid the individual is and how effervescent he or she is about the task and the representation. So separating, not for the entire first meeting, but separating the individuals for a period of time during that initial is something that I would recommend.
Okay, I don't see any other in the Q&A. We're checking the chat to see if there is any questions there. Oops, here's another question. Where somebody answered the question about the dissolution, which is Florida Statute 61.052. No dissolution shall be allowed unless the party alleged to be incapacitated shall have been adjudged incapacitated according to the provisions of 744.331 for a preceding period of at least 3 years.
There you go.
Yeah, so for that, I would say look to chapter 61.052.
Beautiful. Thank you very much, whoever gave us that hint. We appreciate it.
Okay. All right. So I don't see any other questions. Christy, do you see any?
I don't see any on my end. Thanks for all the great info.
Thank you very much, everyone. Be safe out there. Thanks for the invite again, Kathy and Christy.
Yeah, thank you. And thanks to everyone. Our next sessions will start at 2:15 and we'll see you there.
Thank you very much.